All right, welcome back to the Elias Macco Show, second hour of this program, and we'll begin this second hour by talking about the Bill 21 ruling yesterday, Quebec's highest court weighing in, and you can tell by who's celebrating and who's not celebrating how that ruling went, being called a pretty big victory for François Legault and his government. The panel of 3 judges ruling that the law adopted in 2019 stands. So let's go now to Andre Morin, who has joined us in studio, Liberal MNA, and he's the official opposition critic for matters of justice. Monsieur Morin, welcome to the show and welcome to studio.
Good morning.
So, 2:15. I know where I was. I was at home. It was like the Super Bowl for me because I'm on Team Bill 21. So I got the snacks and I put on the news channel. I was ready for the ruling. When the ruling comes out, and I know it's 300 pages. It's a lot to dissect. But your thoughts on the news from yesterday?
I must say that first I was a bit surprised because it's a unanimous decision. Mm-hmm. Three judges. I was maybe expecting someone who could be a dissenting judge, but no. I mean, it's the court,
yeah,
and they look at all aspects of course the questions that were put before them. They assess the evidence, and they delivered a very long decision. You alluded to that, 300 pages covering, one specific aspect of the charter, which is the notwithstanding clause.
Mm-hmm. Now that this ruling has come down, and it's a unanimous decision of these 3 judges, is it time to just leave it alone now and move on? Or do you think it's time to just go next step, Supreme Court? What do you think should happen here? Is it time for Quebec to move on to other things?
I would be surprised. Personally, mm-hmm. I would be surprised if there's no appeal to the Supreme Court of Canada. This bill is divided part of the population. I saw the reaction yesterday. Some were very, very happy. Others were very sad about it. So I wouldn't be surprised. They will have, though, to seek authorization to the Supreme Court. Mm-hmm. It's not a direct appeal, and it's a well thought decision. So let's see what will happen. But I wouldn't be surprised if one of the party is seeking an appeal.
So listen, I get that the parties are going to appeal, but I want to know position of the Liberal Party of Quebec, because all bills are controversial. We can go back in time to the Liberals' Bill 62, which I would say is much worse for religious freedom. Okay, so the position of the Liberal Party, that's what I want to know. Should we just move on? Forget about if they're going to appeal or not, because they're going to appeal. But the position of your party, is it let's move on?
I mean, my position mm-hmm. on Bill 21 first, and this is why the government used the notwithstanding clause. My position is this bill is discriminatory. Mm-hmm. And our position at the Quebec Liberal Party is the same. I mean, we should not use the notwithstanding clause in a prospective way. So we should let the citizen ask the court about their rights, and that's why we have Charter of Rights. And then after that, the government can always use the notwithstanding clause. So my position, and it's, I mean, to me, it is so clear that this bill is discriminatory. This is mm-hmm. why the government used a blanket notwithstanding clause to protect the bill. And yesterday, the Court of Appeal did not look into a deep analysis of the act. They look at the notwithstanding clause, and they basically said mm-hmm. the way it was used by the government, they followed the procedures. So therefore, if you look at the Canadian Charter of Right and Freedom, Section 2, Section 7 to 15, well, we cannot touch that, and it's back in the court of the parliament and the politicians.
Yeah. So do you think that's going to be the long-term position of your party? I see guys like Denis Coderre wants to be the leader of the party saying, Bill 21, happy with it. I see that you're 4% in the polls with francophones, and I think you're going to have to pick you're going to have to pick one big Quebec mission, whether it's language or it's laïcité, You probably should pick both, but you're going to have to pick at least one if you want to get votes from Francophones. So I just, do you think that is this the strategy to get you beyond 4% vote with Francophones?
I would pick the rights of the individuals, the rights of the minorities, and the rights that are stated in the charter. That's what I would pick, because a minority today could be another type of minority tomorrow. And if we have Charter of Rights, there's a reason to it. And it's to protect those individuals. And
So the countries around the world where religion plays a greater role, minorities have more rights?
No, I mean, no, and
I'm just
no,
like
no,
that,
no.
You know what I mean? Like,
Mouvement
Laïque Québécois, the parents that they represent today, right? In the 1960s, they represented Catholic parents, right, who just wanted the Catholicism out of the state. Today, they represent secular Muslims who come to Quebec and are very happy to no longer live in theocracies. And they view Bill 20. They view not having Bill 21 as a bigger discrimination to them than Bill 21, right? And this is why governments have to make decisions. I noticed your look when I mentioned the Liberals' Bill 62. Your party. I know you got elected in 2022, but your party came up with a law and passed it that basically said it's just for scary Muslim symbols. You can't get services, the library, even getting service in a hospital. And I view that as way more egregious than a law that says only people in positions of authority who are getting paid, no symbols while you're on the job. I view that as a much less discriminatory than Bill 62, which the Liberals passed, which is why I find it's confusing at times when I talk to Liberals on this subject, where they land and where they're going to land in the future.
Let me be clear about that. I mean, we are in favor of a lay state, and that's for us. That's a given. Okay. It's in the charter. It was in the preamble of the act. So that's very, very clear for us. And there should be a distinction between religions and the state. That's clear, very clear in my mind. However, we live in a democracy. And parliaments, not judges, parliaments, adopted charters of rights. The Quebec one in 1975, adopted by the Liberal government of Mr. Bourassa, and then the Canadian Charter of Rights, adopted by the Trudeau government in Ottawa. And what we're saying is, if we live in a democracy where we have charters, citizens should have the right to apply to the court to challenge the government and their legislation and make sure that their rights will be respected or will be submitted to an impartial judges. And after that, at the end of the day, politicians, parliament, always have a right to come back and use or not the notwithstanding clause. That's what the Bourassa government did, but it was always very precise. It was not a blanket clause. And that's our position today. And that's why I said that this decision, the court stated clearly that when the government is using the legal procedure, they respect it, and they use the notwithstanding clause, they can do it.
So for you, it's no question going forward, the Liberals wouldn't, because it seems like we were dealing with this for quite some time, this issue of reasonable accommodation and the place of religion in society, and various parties tried to tackle it. What you're saying here is, if Liberals came back into power, you wouldn't go back to something like Bill 62. That was a mistake.
What I'm saying today, our position is we are in favor of a lay state. Laicity is important, and we should have a division between religions and the state. However, if we take power, we also said that we will not use the notwithstanding clause in a prospective way, the way the CAQ government did.
And just on that, so you're in favor of a laïc state, a neutral, religiously neutral state. And I just wonder how that jives. Let's say you are a Jewish person and you are gay, right? And you divorce your husband, you end up in family court. And you end up with a judge who's wearing a religious symbol, and the religious symbol represents a religion that says gays are not good. Sometimes religions say that gays should go to hell, or gays should even not exist, right? So to me, if you say the Liberal Party's for a laïc state, that would mean like a situation we're in, who maybe has a sexual orientation that differs from what a religion would ever have to face a judge that's wearing that symbol. So that's where I don't get it. Like, if that's one thing for the Liberals, it's in there, laic state. That doesn't jive for me. And I like how Bill 21 deals with that.
I mean, in Bill 21, you have some categories of individuals, those who are in authority, and it's restricted categories, and therefore the government said that those individuals should not wear religious symbol, except, and the court recognized it yesterday, the Court of Appeal, except for the members of the National Assembly. Yeah. So, I mean, that's a fact, that's a given, and we'll see. Yeah. I mean, that's what is important for us. Remove the notwithstanding clause, and then let's have a debate in our society, and let's have the court looking at it and see. And the court may say, for instance, that no, it's fine. I mean, the act is reasonable when you do the analysis with Section 1 of the Charter. Yes. But that's our plan. Let's do it.
And by the way, that's why I support Bill 21, because I think if you took away the notwithstanding clause, I think it would still win. But can you explain that for me? Because yes, in fact, yesterday this court ruled elected officials. Can't apply to elected officials. Why couldn't the court, if these three judges felt like it, gotten rid of? Because the teachers thing that was also an option for them. There were groups that wanted the whole thing thrown out. Why did the court just say, you know what, you got to point on the elected officials, but everything else stands? Why do you think they did that?
Well, I mean, first of all, they attached it to Section 3 of the Charter, and my understanding is that notwithstanding clause does not apply to Section 3.
Gotcha.
So they were able to look into it, and they came up with that decision.
We're running up against the clock, but to end off, is this subject, Bill 21, internally within the Liberal Party? Does it create the same kind of debate we're having right now? Is it a contentious issue internally?
Well, I must say that we have a very strong caucus. We have very, very good discussion, and that's very important. But at the end of the day, we have a good leader, Marc Tanguay, we have a strong caucus, and we speak with one voice.
André Morin, Liberal MNA, and the official opposition critic on matters of justice. Thank you so much for your time. Come back to studio anytime. I should note this. Marwa Risky, Greg Kelly, and you in studio in 1 week. J'adore ça. J'adore.
Thank you for the invitation. Have a good day.
You too.